intro. All right. Happy Tuesday, everyone. My name's Kim Chung, and I'm with the St. Paul Area Chamber of Commerce. Thank you so much for joining us today for our first webinar in our Small Business Bite series. So we are offering a number of different subjects that business owners like you might be interested in exploring, leading up to our Small Business Summit and Expo happening on Friday, May 8th. Registration for that page has just gone live, so if you are interested, please check it out. It's a really great opportunity for folks to come learn from different session speakers and connect with others, local businesses in the area. We are so excited to be presenting you with our important topic for today, understanding Minnesota's new mandatory break rules and how they impact your business, your employees, and your day-to-day operations. We understand that for small business owners, staying on top of policy changes isn't just helpful, it is essential, but it can also be overwhelming. And that's exactly why we're hosting sessions like this to break down what's changing, what it means for you, and how you can move forward with clarity and confidence. So today we're especially grateful to be joined by someone who not only understands these new laws deeply, but also spends his time helping employers and communities across the state navigate them in a practical way. So I am pleased to introduce Dave Skovholt, Education and Engagement Supervisor in the Labor Standards Division at the Minnesota Department of Labor and Industry. Dave has been with DLI since 2018, where he led efforts focused on Minnesota's labor standards laws, including wage theft prevention, child labor, protections for pregnant and new parent employees, and other key workplace requirements. He regularly travels throughout the state working directly with business groups and community organizations, so he understands the real questions and challenges employers are facing. Before joining DLI, Dave also served as a labor union business agent where he negotiated collective bargaining agreements across Minnesota and the Midwest. So he brings a very well-rounded perspective to today's conversation. Dave, we are so grateful to have you here with us today, and thank you for helping us make sense of all these changes and what they mean for our business community. So with that, I will turn it over to you.
Thank you so much, Kim. I'm really excited to be here. I really appreciate the invitation. The department is always looking for ways to communicate with employers of all different sizes. And like you said, we know the challenges that small businesses face, especially because there's been so many changes to labor laws over recent years. So I think I need to adjust this slightly. Okay. So here's the presentation. Got it up. Hopefully that should be working for everybody. I'm just going to make one more adjustment on my end to get so I can see what I need to see, my notes. Just got to do one thing here. I'll move this over. Sorry, guys. And pull this back up. All right. So let's get into it. And I know we're going to have time for questions and answers, and I want to be able to interact as much as possible with you all and talk through your situations as we go through the presentation. So first is just to start with an overview of who the department is. As employers, you're going to be interacting. You likely interact with our department already, and you can interact with us in many different ways. So just want to do the very quick familiarization of who we are, what we do at the Department of Labor and Industry. We do have the Apprenticeship Minnesota program. So we oversee many apprenticeship programs and work with employers on those workforce development opportunities, construction codes and licensing. So that's our biggest division, and we're making sure that the construction that's done across the state is done to code, and that people that need to be licensed are getting tested and are properly licensed for those trades. Labor standards is where I work. We'll talk more about that. We have Minnesota OSHA compliance and workplace safety. Those are both two different sides of OSHA. Compliance is the side that goes out to workplaces and does inspections. And if they do find violations, they are issuing fines, penalties. They're working with employers to correct those issues. Workplace safety consultation is the proactive element of OSHA where employers invite OSHA to come and to work to look and hopefully find resolutions to any safety issues that are found. So with that, there is some opportunities to avoid kind of the punitive side of potential safety violations. And we have projects and planning, which is kind of a catch-all, and then workers' compensation is also another big division, so you might be working with us there at some point. Labor standards, again, where I work. So we enforce and oversee the Minnesota Fair Labor Standards Act, which is our longest standing labor standards law in the state. And it's very similar to the federal Fair Labor Standards Act, which many of you, I'm sure, are aware of. So it covers, the state law covers the minimum wage, the overtime law requirements. It's also where the rest and meal break laws fall. And we'll come back to that. And that's important that it falls under that law because it impacts who it covers. So Women's Economic Security Act, that covers pregnant and new parents in terms of accommodations they should receive on the work site if there's a pregnant worker, nursing accommodations after birth, and then the unpaid pregnancy and parental leave law that was in place before paid leave and still remains in place. We have child labor standards. So if you're hiring anybody under the age of 18, so that's going to provide guidance to you in terms of what age the employees can be hired at, and that's 14 in most cases. And then, what hours can they work? There's restrictions on hours for those that are under 18. So being able to work until a certain time, being able to start at a certain time in the morning, and then what types of work they can do, and what types of hazardous situations they can work under. And there are limitations. It's set up so that there's a progression of more availability to do more things and work more hours as they get older, so that they can have those good positive work experiences to start. Earned sick and safe time, you're all familiar with that, I'm sure. So that's another one. And then Wage Theft Prevention Act, which passed in 2019. So lots of different laws we oversee in labor standards. This one is a reminder that there are different labor standards and wage and hour agencies. Again, something you probably are aware of, but kind of a lot of questions we get is things kind of like, how does it work together? And if there is a different standard, then which one applies to us? So for example, I think that an easy one to kind of think about is the minimum wage, right? So we have a federal minimum wage at $7.25. We have a state minimum wage, and then we have the city minimum wage in St. Paul, which is over $15 an hour. So we have those three, and the state is in the middle, and kind of like, well, which one applies to me? How does that work? So whether it's the minimum wage or it's a child labor standard, what you're always looking to do as an employer is what is the highest standard for the employee? And then once you meet that, you're going to fall into compliance with the other requirements. So if you're meeting St. Paul's minimum wage, you're going to meet the state minimum wage, you're going to meet the federal minimum wage. Again, that's the easiest example of minimum wage because it gets a little more complicated because sometimes the federal standard could be higher, sometimes the state standard could be higher. And then potentially you have a city ordinance like minimum wage where that's higher. So here's what we're going to talk about today. The updated rest and meal breaks. I'm going to touch on the job protections under the Minnesota paid leave law, because that's something we also oversee in labor standards at the Department of Labor and Industry. And I'm going to talk about earned sick and safe time rulemaking, which will impact guidance, and it will impact implementation of earned sick and safe time in your workplace. Okay, so we're going to start with breaks. and potentially some of us are coming off breaks because it's 1 o'clock. So we can think about this in terms of our own break that we might have just taken. So coverage, again, I talked about that. It's important that the rest and meal break law falls under the Minnesota Fair Labor Standards Act. And why is that important? It's important because that act only applies to certain types of workers. And there's exemptions for other types of workers. So as we know, there are certain people that are exempt from overtime, and that's where most people relate to this. And we have in the middle there, the second bullet point, it talks about bona fide executive, administrative, and professional employees, right? So it's those exempt employees and non-exempt employees, that differentiation, right? And so if somebody is properly classified as an exempt employee, then they do not need to be provided breaks in the way that we're going to talk about in the next sets of slides. Of course, they can, and of course, an employer can allow those breaks, but they would not be required. So breaks are required. The breaks that we're going to talk about, both meal and rest breaks, are required for non-exempt employees. Non-exempt employees, right? So, maybe this is an opportunity to double check to make sure that you're classifying people correctly if you have people that are classified as exempt. And if you do want to, I guess one other thing I'll say about this, if you want to check the full list of who is exempt and non-exempt, one is we have a good web page on DLI's website that kind of goes through that. Secondly, it's looking at Minnesota Statutes 177, and you're going to see the full list of different types of workers. For example, you can see on the screen here certain agriculture workers, seasonal day camp staff employees, and there's other specific examples that are cited there. Okay, so one thing that's come up often is, hey, now we have a breaks law. We didn't have anything like this before, but we are moving from some requirement. There has been a requirement around both rest and meal breaks, which are separate laws. Those are not the same, to a more to a different one. So let's talk briefly about what it was in the past. And maybe you weren't aware of this, and you can, as we go through it, you might be kind of get a better understanding why you might not have been aware of it. So rest breaks, essentially employers were required to provide adequate time to use the bathroom, the restroom, within every 4 consecutive hours. So during my time at Labor and Industry, we've had very few kind of complaints that had that this was actually happening, where somebody was actually restricted from using the bathroom for every 4 hours. So this is not common during my time. You can see here on the second bullet, it talks about that different rest breaks may be established through collective bargaining agreements. And if any of you work with collective bargaining agreements, union contracts in your workplace, that provision was in the previous law, and it's going to stay with the new law, and you'll see that as we go forward. Okay, so what was effective this year in January? So this is all in place right now. So what do we have for rest breaks? For rest breaks, an employer must allow at least 15 minutes or enough time to utilize the nearest convenient restroom, whichever is longer, within each 4 consecutive hours of work, right? At each 4 consecutive hours of work. So if we have somebody working a 4-hour shift, they must be allowed at least 15 minutes. And you might be asking yourself, what does it mean to must allow? And we're going to get to that. That's been a big question as well, talking about what it means to allow the break. So, and then we see the collective bargaining agreement language stays here. So if you do work with the collective bargaining agreement, you may have a different type of agreement around rest breaks. Okay, so let's just do the quick comparison. We went from adequate time to at least 15 minutes or longer. How often within each 4 consecutive hours? And what is the purpose? So the purpose of the law previously was just to use the restroom. Now it's to be able to use the restroom and essentially to take some rest time. And let's go over an example. So we have here an example. We have somebody, and you can see in the photo, this looks like a distribution center or warehouse. And we have Sarah working, it says 9 hours. The length that she's going to be at work is 9 hours. She's going to be, it's actually an 8.5 hour shift if you consider that she's taking a meal break from noon to 12:30. And in this case, it takes Sarah approximately 10 minutes to walk to, use, and return from the nearest restroom. So 2 questions. If you want to put answers in the chat or just think about them, that's good. So how many rest breaks must the employer allow Sarah to take? So the answer is two. The answer is two. There's at least, right? There's 2 4-hour segments. Thank you, Chelsea, answered. There's at least 2 4-hour segments here, right? And that's pretty easy to answer, right? And how much time must Sarah be allowed for rest breaks? Again, I think we know this one because it was clear on the last slide. It's at least 15 minutes. So and it may be longer if it takes longer. So if we can imagine a giant distribution center where Sarah is working here in the photo, and let's say they have a restroom way at the end of the end of the building, and it takes Sarah 10 minutes to get down there, and 10 minutes on the way back, and then use it's another amount of time to use the restroom. That may add up to more than 15 minutes. So in most circumstances, it's not going to be over 15 minutes, but certain types of situations, maybe it does take longer than 15. All right, so let's go over meal breaks. So meal breaks, again, this was the previous law. So if somebody was working 8 or more consecutive hours, the employer needed to permit the person sufficient time to eat a meal. The law didn't define, or the Minnesota administrative rules did not define what sufficient time to eat a meal was. So that was always a little bit of a gray area. But that was the previous law, and we can see that the collective bargaining agreement language is here as well. And now let's talk about what it changed to. So what did it change to? It changed to if the person is working 6 or more consecutive hours, a meal break of at least 30 minutes must be allowed. And we can see the different meal break language remains for the collective bargaining agreements. The chart to review previous to current. What did it change? It changed from sufficient time to now we have a clear amount of time. It's 30 minutes. How often? It changed from 8 to 6 hours for consecutive shifts when it applies, and the purpose remains to eat a meal. So an example here, we have somebody working a 12-hour shift, right? A 12-hour shift, probably more common in healthcare, but here we have like a grocery type of photo of somebody doing that. And if that's the case, and we have Adam here working for 12 hours, how many meal breaks must Adam be allowed to take? Let's see if I can get at least one person to respond in the chat here. All right. Yes, that's right. It's one. And sometimes people get a little bit tricked up because the previous one is at least one for every 4 hours for rest. But if it's a 6 or more hour shift, only one meal break is required. Again, employers could definitely provide more meal breaks. Let's say somebody was working a 15-hour shift. They probably would need more than one meal break, but it's just one in this case. Okay, so getting back to what does it mean to allow? And again,
Dave,
this is where, yes.
There was a quick question from Chelsea asking, does the meal break need to be within the first 6 hours?
The law does not require that. If the shift was to only last 6 hours, then of course, yes, it would need to be there. But the law doesn't state at what point of the shift either of the breaks for the rest or the meal breaks need to be given. So that's a place where employers would have discretion about where to place those breaks as long as they were provided when the shift was 6 or more hours. So hopefully that answers it, but if not, please let me know. Okay, so let's talk about what does it mean to allow breaks. And essentially what we're looking for here, the department, if we were to analyze a situation, would be does the employer voluntarily allow that employee to make the choice, whether they want a break or not, so that the employee is making the decision whether they would like the break or not. We have had lots of employers approach us about concepts of waiving breaks. And certainly in certain situations, we could see where an employee would want to waive their break. So that is an option to set up some type of system. The law does not lay out what that system should look like, does not, the department does not have a sample waiver form. We don't have anything like that, but we know that employers are going through those types of thought process and sometimes setting up those types of system. Again, making sure that the employee is voluntarily making that choice is important. If we were to analyze, again, one of these situations, some of the things that we would look for to see if the employee had been able to make that choice, and if the employer is allowing breaks, is we would look for, does the employer have a breaks related policy, something in writing? Have they communicated that policy? Have they informed their employees about that? Probably give it to them in writing, let them know in a meeting or an email or something like that, making sure they're aware they are allowed those breaks. And then do the work circumstances make it possible for employees to take breaks? And that's important. I have a few examples of things we've been finding since this law has passed that I'm going to talk about in a few minutes. And some of those examples go through situations where the work circumstances don't actually make it possible or make it difficult for that to happen. So if the employee does voluntarily waive their breaks, it is a best practice. It's a good practice to confirm that in writing. And again, because the law does not specifically lay out what that process could look like, you may want to consult an employment law attorney to kind of set up a system like that. Additional things to think about when it comes to breaks. Okay, so we have our administrative rules, and administrative rules clarify what the laws mean and give guidance to employers and employees about how they apply in workplaces. So one of those administrative rules talks about that breaks of less than 20 minutes must be paid. So that's something to be, so assuming that your rest breaks are 15 minutes and your meal breaks are 30 minutes, you have rest breaks that would need to be on paid time, compensable, and then meal breaks could be without a compensation. They could be punched out, essentially. So it says, yeah, other breaks can be unpaid if the employee is completely relieved from work duties, right? And that's important. They're not working during that break time. That can make that time, as long as it's more than 20 minutes, that can make that time be unpaid. So the law does say that there are liquidated damages equal to the amount of time and wages that the employee would have been paid if they would have been working. If they missed their break, could apply, and that would be something that employees would likely come into play, or more likely come into play if there was an investigation by the department, or if the employee took a private right of action to address the situation. Another question that's come up a lot that I'm going to touch on here is the location of the breaks. And this is not changing. This is the same as the previous law was, but employers can require employees to stay on site at their work site for either the meal or the rest breaks, even if it's the even if it's the punched out unpaid time, you can require that person stay on site if you'd like to. Okay. All right. So another thing to think about is hours worked. So what are considered hours worked? And So hours worked, essentially, again, what hours need to be paid or what hours are compensable. They include a lot of things, and throughout our work, we find that sometimes this is where employers make mistakes. This is they're not. Some of this time is not compensable. So this slide goes through some of those examples, and there are always exceptions to certain things, but generally training time, cleaning time, work performing duties needs to be compensable, right? But the 30-minute or longer meal period does not is punched out, so that's not considered hours worked. And why that's important for the meal and rest break, I mean, there's different reasons why it's important, but one of the reasons why it's important for the meal and rest break requirements is if we think back to the um, concept of the rest break of 4 hours consecutive worked. So let's say, for example, somebody was working a 6-hour shift, and then the employer put a 30-minute meal break in the middle of that 6 hours. So they were going to be paid for 5.5 hours with half-hour meal break. That time on either side of that meal break is not 4 hours. It's less than 4 hours. So the employer in that situation would not be required to provide meal breaks for that shift. So that's something to kind of think about is how does your shift lengths work? Where do you place your breaks? And what does that mean in terms of the requirements and how they kind of fit together? All right. So here I'm going to give a couple examples of things that we're finding at the department, situations that have come to us since the break law has passed. But I also want to highlight that we have this web page with great resources, videos about the breaks law. We have the comparison chart that I talked about in the presentation. We have more Q&A and other resources, and our staff is always happy to take phone calls as well from both employers and employees. So a couple examples. One, we have like a chain coffee shop type of situation, and either the rest breaks are not being given at all, or the rest breaks are just frequently interrupted and the person is not able to finish. So in that situation, there's probably different reasons why that happens, but in that situation, the employer would want to figure out how to make it work because the law does require that those breaks be allowed. A second situation is a security company type of situation with 6-hour shifts. And the employer is providing 15-minute rest breaks, but the rest breaks are being deducted from the wages. So as I said before, breaks of 20 minutes or longer that are uninterrupted can be unpaid. But in this situation, we have a 15-minute break, so that does need to be compensable time. A third example, we have a housekeeping situation in a hotel. And in this housekeeping situation, we have where the housekeeper, the room attendant, has their meal breaks consistently interrupted. So not too dissimilar from the first situation. And they're having their meal breaks interrupted and they're not being put back on the clock either. So two types of issues there. And then a fourth and final example of something, a situation that we've come across is a healthcare clinic type setting, and where the worker is working 12-hour shifts and they're only being provided a scattering of 5-minute breaks here and there to use the restroom, and they're not being scheduled any breaks. So all those are all situations that employers are going to need to adjust their practices and think about how they can schedule and have enough staff available to cover those situations. Okay, so that's the whole meal and rest break situation. I know I went through that pretty slowly, but hopefully that all makes sense, and happy to answer or questions or talk through scenarios with that.
There was one question that came through from Latasha Reed, owner and founder of Elevated. It says if they don't waive the break, but the employer is still expecting the employee to work through it, Um, Latasha, was there more to your question, or were you just asking what would happen in a scenario like that?
Well,
Uh, let's see. Jenna, is there a way for her to be able to come off mute? Sorry
Yeah,
for
she's
the.
able to now.
Okay, perfect. Latasha, are you able to come off mute?
Just click
Oh,
the
can
microphone
you hear
button.
me?
Yeah.
Yes, we can now. Mhm.
Okay. So I am a actual person who owns a company, but I also work for a hotel chain here as a very, very part-time employee. And it's an atmosphere where they schedule people to work 8 hours and there is no one to relieve us, like none of us. And I had a health condition one night, and had to immediately just throw up a sign. And I alerted the owners, like, hey, is there a way we can figure out how this works? Because I'm a diabetic. I almost fell out at the front desk. It was so busy. People were calling, coming down for this, and this. And literally, the response that I got from the management or the lower level management was that they said, well, if she can't work it, schedule people who can. And I have not been scheduled for work for 2 months.
okay, that's pretty concerning situation and potentially retaliation for, kind of wanting to address that situation. So I would say, please call us and talk. Let's talk through that situation. Um, and we know that there are certain situations where staffing is a challenge. And so to say that this is not a difficult thing for employers is not realistic, right? This can be a difficult, just like any new law and any new requirement, figuring out how to make it work in the workplaces can be a challenge. But certainly not deciding not to put somebody on the schedule because of that is very concerning, and that could be potentially a violation of different sets of laws, including FMLA or um, ADA and other accommodations that need to be provided in those situations.
Yeah, I'm confused on if I actually still work there. I'm still allowed to be in the system. I still get the schedules when they come out, but I'm never on the schedule. And I don't know if they're waiting for me to just quit, but I'm not quitting. I think they need to fire me if they don't want me to work. But right now, I'm still, I guess, considered a payroll employee, but I have not been to work since mid-January when I raised this concern.
Well, thank you for sharing, Latasha. And again, maybe give us a call and we can, our staff can talk through that with you and what options are available.
Okay, I'm going back on mute.
Okay, so I'm going to move forward, but if there's other things about breaks that people want to bring up, happy to do that. So earn sick and safe time rulemaking. Um, if you're in St. Paul, and I know a lot of you are, then you're familiar with earned sick and safe time for longer even than people in employers in other parts of the state, because we've had the city ordinance for longer. But as again, talking about when we go back to when we have two different sets of rules or requirements. So we have the city earned sick and safe time, and then we have the state law. So if there's provisions in the state law that are more protective to the employee, then those will apply as well to St. Paul. So the St. Paul ordinance does not override the state law when it comes to those requirements. So rulemaking is a process I touched on earlier with 5200 with labor standards laws, and we talked about the 20 minutes guidance for when break periods can be unpaid. So rulemaking clarifies laws, and we're going through the rulemaking process. We're very far down the line in that process, and it's in the hands of administrative judge right now, and we've had a hearing recently, and they're kind of gonna come back to us very soon and tell us which parts of the rulemaking proposals can go forward. So here I'm just letting you know about the process. It's not in place yet. It's not, these rules are not final yet, but some of the things in the draft of, and you can go to our website and look at this if you'd like to, but would be defining what the accrual year is. So in essence, it's going to make the calendar year the default accrual year if the employer has not defined it otherwise. Most employers do define it, so that might not be an issue for you. The location of the hours worked. Now, if any of you ever have employees that work out of state, this would help figure out if those hours apply for purposes of earned sick and safe time accrual or not. This is going to be probably more consequential for employers that are have employees kind of working in Wisconsin, Minnesota, or maybe the Dakotas and Minnesota, kind of on those border communities. Indeterminate shifts, how does the employer handle if the employee is working, let's say, as a restaurant server and the shift is unclear how long it will be, and then how many hours they should give the employee for earned sick and safe time. It's going to talk about advancing earned sick and safe time. So we have different methods. The employer can use an accrual method. They can use a front loading method. If the employer wants to advance earned sick and safe time, this kind of lays out that process a little bit more. And then finally, something that's probably of interest to a lot of employers is misuse. So under what circumstances can employers deny earned sick and safe time if there's a pattern of misuse or suspected misuse, essentially somebody not using earned sick and safe time for one of the reasons that the law requires. So there will be some, if that was to go through, there would be some ability for employers to kind of use that to examine situations of potential misuse and then make a call on whether to what to do with that. So that's ESST rulemaking. Now I'm going to talk quickly about job protections under the paid leave law. So just essentially, and I think a lot of you probably know this, but the paid leave law is administered by the Department of Employment and Economic Development. So they're going to be the go-to for questions about your employer portal, about application process, about how the program works in general and in different obligations that employers and employees have. Where we come in is that we enforce the paid leave job protections. So paid leave job protections are here on the screen. There's 6 of them, and I'm just going to briefly run through some of them that are more kind of relevant or more common situations, and then other ones I'm not really going to touch on. So the ones I'm not going to touch on, I'm going to just briefly let you know what they mean. So the waiver of rights void. An employer cannot agree with an employee to waive their rights to paid leave. So any type of agreement like that would be void and unenforceable. The assignment of benefits prohibited. So employers cannot use an employee's leave payment to collect a debt. So if there's some type of debt situation between the employer and the employer, the employee and employer, the employer cannot require, hey, you need to pay me through your paid leave payments to pay me back. And then finally, the last one I'm going to touch on here before we go to the slides with more detail would be employers cannot overcharge an employee for a paid leave premium. So which is more than 50% of the premiums payment, or deducting payments that take the employee's wages below minimum wage. And as you know, likely know, there's different allowances for deduction amounts for large and small employers under the definitions of the paid leave law. Okay, so these are the ones that are more common. So retaliation or interference, and that term retaliation or interference, that really can be kind of looked at as like negative consequences somebody might face for using or applying for paid leave. So we have some examples here on the screen, and We have an employee that's informing their employer they're going to apply for paid leave, and then they end up being terminated as a consequence of that. So that would be, of course, that would be prohibited, and or somebody having a reduced or demoted schedule when they've applied for intermittent leave because of a serious health condition. So reinstatement, this is something when somebody comes back from paid leave, let's say it's not an intermittent, let's say it's an extended, like a childbirth type of leave, that they need to be reinstated to their previous position, or position of equivalent, if the position has changed. The reinstatement requirement takes effect 90 days after the employee's date of hire. There is an asterisk there because let's say it's a childbirth situation. I talked about earlier the unpaid Minnesota pregnancy and parental leave law. So under that law, somebody is required to be returned to their position, even if they work less than 90 days for their employer. So a little complication there, but essentially, if they are taking medical leave in their first 90 days of employment, they may not have job protections. You may not have to return them to their position. Right, let's go to the next one. Just see. Oh, I missed this. Insurance continuation. And so this is very similar to FMLA if you worked with FMLA in the past. And it's really that the group insurance premiums need to be continued while somebody's out on leave, just as if they had continued working during that time. And then employers they figure out a system to, if there's a kind of an employer portion, employee portion for payment, there's different ways that employers are figuring out how to continue to collect that payment, or a different system. And this provision can be waived for certain employees in the construction industry. Okay, and then I'm gonna just jump forward to the final paid leave slide, and talk about a couple other key things with reinstatement. And that is that when the employee is reinstated, they need to be reinstated to the same position or one with comparable duties. Like I noted that earlier. The reinstatement cannot result in reduction of hours or compensation, and an employer may not terminate an employee on leave unless the position is subject to a layoff. So for example, if everybody that is in a certain job classification is laid off and one person is on leave, that would be likely an example of a situation where the employer would not need to reinstate that in person. And employers can allow part-time leave, part-time return to work part-time, and that the employee would need to be able to retain their ability to come back full-time at the end of that leave period. All right, so that's just kind of overview of some of the job protections. But if you have questions about that, we have some resources. There's the paid leave job protections I talked about earlier, the breaks webpage, the Earn Sick and Safe Time rulemaking and information page. So that's all good stuff. There's our phone number and our email. We are happy to take phone calls or emails from employers. We do every day. We take probably 60 to 80 intakes a day, inquiries of different kinds. And you don't have to say who you are or where you're coming from. You can just call and ask with a question. And then we always recommend our bulletin to sign up for updates. So I think that is my last slide.
Thank you, Dave. That was very helpful. I Does anyone have any questions? You can feel free to just come off mute and ask them directly. For the folks that have joined the call, was there something specific that brought you to this webinar? Curious if there's maybe something that you didn't get answered, or if there are certain topics you'd like more information or resources on. Maybe everyone's really tired after lunch. Or Dave, you did do a great job of presenting everything. Oh, Cindy, you can't disable the mute. Jenna, is there something that needs to happen for Cindy to be able to come off mute?
Hi,
Oh, there you go.
thank you. So I'm a restaurant owner, and we've always just allowed our staff to break whenever they need a break and to sit and eat a meal whenever they need to. Um, so most of the time, the kitchen staff likes to sit and eat all together and have a meal together, um, which means, I have four people who are sitting and eating a meal, which is fine, but sometimes an order might come in, so they get up, they cook it, then they go back and they sit down. I'm just curious about whether that is okay.
Yeah, so if we're just talking about whether you're allowing the breaks of 30 minutes, so let's say that somebody did want to take a 30-minute uninterrupted break. I mean, then that sounds like there could be an issue there, right? Because potentially they're having their break interrupted. Alternatively, we talked about that the employer must allow the employees to take the break. And and then that certain employers are setting up systems to kind of waive breaks or and things like that. And one thing, I can't give you legal advice. I can't kind of tell you what your, too much about what your options are outside of what the law kind of talks about. But if there was a waiver system, if the employer was in fact allowing those breaks to happen, but the employee and the employer decided to kind of waive that system, and potentially they could agree to something else. And something else could potentially be the system that you have in place there. So that is a little bit tricky because I can't, like, again, I can't give you legal advice to what that would look like, but under certain circumstances, that I can say that that might be a legal or allowed system.
Right. And we never make them clock out or anything. It's all on the clock. I did talk to the city of Minneapolis, and they recommended that we force them to clock out and take their meal break and then clock back in so that there's a record of us allowing the break and making it unpaid. I don't know. So it would just be a pretty significant change for my staff, and they would probably question why this would be happening since they seem happy about the way things are now. I
Yeah.
just don't want to have a situation where in the future, something does, somebody is unhappy and then makes a complaint. So
No, I have to learn more about, the recommending of the punching out, but that's not something I'm going to kind of say at this point. But, um, but again, potentially if there's a waiver type of system, then that opens up to an alternative process that the employer would establish with the employees. So I have to leave it at that, I guess.
okay, thank you.
Right. Any other last questions while we've got Dave on the line?
Well, I just want to say thank you. I think it seems like we're wrapping up, but if there's anything last, I'm happy to take it. But just really appreciate this, and happy to provide. Our team is happy to provide more help, and please use our resources to your benefit.
Amazing. Dave, before we close out, could you please share your email address or a way for people to get in touch with you if they had some more they wanted to speak with you about privately? And
Sure.
everyone, thank you so much. We will be sending out an email recap with the webinar and the slides. So please let us know if there's any other topics or interesting challenges that your business is facing now that you'd like for us to develop a new webinar around. And yeah, with that, thank you everyone for your time and really appreciate you being here today.
Bye. Thank you.
Bye, Dave.